Dear ladies and gentlemen, on behalf of the Belgian Cabinet, the Minister of Finance, and the Federal Public Service, it is a great pleasure to welcome you all to this international tax event. My name is Mario Rijkaard, and since the start of the presidency, I am head of Belgium's International Direct Taxes Department. First of all, we are very pleased that we can share this event with a large audience. We have both the people present here in the beautiful Brussels Pacheco Hall, and on the other hand, we have also a considerable number of participants following through the live stream connection. In total, we have 300 participants. It is a gratifying observation, of course, that this initiative has received a lot of support. In addition, it also shows that the topics on our agenda today are both current and relevant for our business. When we talk about international taxation, the past decade has shown a particularly strong increase in supranational regulation and cooperation. We are witnessing an extremely rapid and global evolution, affecting various levels and domains. However, this evolution also creates a new playing field in taxation with many challenges. The implementation of the new systems, let's think about Pillar 2, BEPS, various DAC directives, etc., they show that there is a lot of work on our table. I am convinced that we can successfully overcome these challenges thanks to constructive cooperation between three parties. First of all, the government, that's the Cabinet and the Federal Public Service. Second, the business, and third party is the academic world. And that is also the approach for today's event, both in the audience, on the live stream, and also in our expert panels. We have representation from these three parties. Thanks to the input of business and academic world, we as a Belgian government can represent the interests of the economy successfully on an international level. Now, considering this international representation, it is of course a very interesting moment. As you know, since January the 1st, Belgium has held the presidency of the EU Council, allowing us to contribute significantly to the progress of international tax policies. At the beginning of the presidency, our Minister of Finance has set out the priorities with also some specific tax-related topics. A lot of work has been done since then. We have made substantial progress over the past 5 months. Our experts, along with other stakeholders and the competent cabinet, have achieved significant milestones within both the OECD and the EU frameworks. Even at the level of the United Nations, we have taken the first steps toward enhanced tax cooperation. Now, central to all our achievements and objectives is the promotion of a well-functioning economy while upholding supranational agreements on fair tax allocation. One of the top priorities set out by our Minister of Finance for the presidency was undoubtedly the creation of a task force on taxation and cross-border working. It is a fact that international taxation is not only confined to the global stage. As an open economy centrally located in Europe, Belgium also places great importance on seamless cooperation with neighboring countries. Our tax policymakers aim to stay abreast of current socio-economic developments and adjust relevant regulations accordingly. And this brings us to focus to this afternoon's session in the evolution of hybrid work and cross-border mobility, which has risen the urgency for an updated regulatory framework. Belgium has embraced this responsibility during its presidency. We are honored to present the TaskForce accomplishments today. Like I said before in this introduction, cooperation with both academic world and business creates a leverage effect towards success. So we are really grateful that we can count on high qualified participants in our expert panels. Many thanks to you all. I will now hand over the floor to one of my own experts, Angie Clocheret, who will, no doubt, enthusiastically moderate the sessions. I thank you once again for your attendance, and I wish you all a fascinating and enriching experience. Thank you very much.
Thank you very much, Mario. And I would also like to warmly welcome everyone here in the room and also the people who are following online. So I am Angie Clocheret. I work for the General Administration of Strategic Expertise and Support at the Federal Public Service of Finance, Belgium, in international taxation. And I will be the moderator for today. And we have some very good panelists today. I'm very happy that they could come. Indeed, working from home or teleworking has become the new normal. I, for one, as many people, am very happy about that. In fact, I wanted to work from home today, but moderating the debate would be a bit difficult to do it. But who would have dreamt that a few years ago that our home-to-work commute, for instance, could just be from our bed to the next room at a desk in our house. And even better, that we could go to work in our pajamas and no one would even notice it. Teleworking has a lot of advantages, but today we are here together to discuss some of the difficulties regarding international taxation, regarding taxation as a whole, associated with the teleworking phenomenon. So now I am very honored to present the first speaker of today, Mr. Yves van Brussel, who works at the OECD Center of Tax Policy and Administration, where he is an advisor, and he does a lot of important work on, for example, the two-pillar solution, the OECD Model Tax Convention, and of course, global mobility of individual workers. And Yves is going to do a presentation on the OECD work concerning the issues of this colloquium. The floor is yours, Yves. You can come.
Good afternoon, everyone. Thank you for the kind introduction, Angie. Hello, I'm Yves, and I work in the tax treaty unit at the OECD. It's a pleasure to be here today to give an update on the work on global mobility that the OECD is undertaking. So I have some slides. So we'll start with a bit of scene setting. As we all know, the physical presence of individuals and employees is a key element for tax purposes. That means that increased levels of global mobility will raise many questions, ranging from corporate income tax, including transfer pricing, to personal income tax, social security, and administration. Before turning to the work that is currently taking place at the OECD, I'll start with a brief recap of past work. Working Party 1, which is the body that's responsible for the OECD Model Tax Convention, already considered back in 2011 whether a home office could constitute a permanent establishment. That work at the time led to changes which were included in the commentary to Article 5 of the OECD model, which are still here today, and which were finally included in the model as part of the 2017 update after the finalization of BEPS Action 7. Then, as we all experienced during the COVID pandemic, responding to that required major changes in our daily lives. And in order to provide more tax certainty to taxpayers during that exceptional period, the Secretariat issued guidance on the application of tax treaties during that period. That guidance was issued by the Secretariat and supported by Working Party 1. Following that guidance, business stakeholders and jurisdictions remained committed to working on global mobility. However, the work on the two-pillar solution, which you'll be familiar with, I imagine, took priority, and the work on global mobility was included as a priority project for the OECD's program of work for 23 and 24, so for today. Then we'll now look in a bit more detail at the work that is currently taking place, which consists of two main elements. First, there was a stakeholder day on global mobility organized at the OECD in September of last year. And then secondly, there was a first meeting of Working Party 1 on global mobility that took place in February of last year. Starting with the Stakeholder Day, very briefly, it was a day during which business stakeholders, academics, and practitioners were able to share their views on the global mobility issue. And the day was also attended by all Working Party 1 delegates, so they were in listening mode, listening to all the relevant stakeholders presenting their views. Business stakeholders emphasized that the mobility of workers became a really pressing issue for them, because more and more workers demand flexible working arrangements. Business said they are trying to facilitate that, but they face many obstacles, including tax obstacles. And among those tax obstacles, two big tax obstacles stand out. And the first one is PE exposure, and the second one is payroll tax compliance. Then turning to the work that Working Party 1 is currently undertaken. So in February of this year, Working Party 1 had its first substantial discussion on global mobility. The aim of that meeting, being it the first meeting, was to scope the future work on global mobility that could be undertaken within Working Party 1. And to do that, Working Party 1 considered first a working definition of teleworking abroad, as well as some common teleworking scenarios. And then the discussion focused on issues arising under Articles 4, 5, and 15 of the model, so residence, PE, and taxation of salaries. There were also some other issues that were discussed, but to a limited extent, such as the taxation of pensions. So now next we'll look at the current working definition that's being used, as well as the common scenarios, before giving a recap of the meeting itself. The current working definition of teleworking abroad focuses on employees that work physically from a jurisdiction using information and technology, communication technology, for a business resident in another jurisdiction. So there are a couple of key elements to this definition, which seeks to ensure that the work is appropriately delineated. Those elements are first, the focus on employees, as issues involving non-employees appear less pressing for the time being. Second, very importantly, for treaties, a cross-border element, which means that the employer is a non-resident of the jurisdiction in which the employee is physically working. And then third, teleworking, which means that the employee uses his laptop, information and communication technology to carry out the work. There are also some other elements that are informative of the teleworking that is taking place. And those elements can vary depending on the case we encounter, and are the location where the employee works. That could be his or her home, but that could be equally any other place. And then the duration and the intermittence of the teleworking as well. So with that working definition of teleworking abroad in mind, we can look at the three main scenarios that were discussed by Working Party 1, and I'll cover each one briefly. We start with the box on the left side on the slide, where we have an example of permanent teleworking abroad. Here we have an employer located in jurisdiction A and an employee located in jurisdiction B, and that employee works from home on a full-time basis. Then moving to the box in the middle of the slide, we have an example on hybrid teleworking abroad. The difference here with the previous case is that the employee works for some part of its time, both in jurisdiction A and in jurisdiction B. So that could be a cross-border commuter, but it could equally involve an employee traveling from non-neighboring countries to another non-neighboring country. However, such employee could, of course, qualify for certain frontier worker arrangements, if applicable, of course. And potentially such a scenario may be more common in Belgium and its neighboring countries. Then on the right, the final case that was discussed, we have temporary teleworking. In this scenario, the employer and the employee are both residents of the same jurisdiction, and the employee teleworks from another jurisdiction for part of its work time. Usually that is on a temporary basis and connected to a visit to family or for holiday purposes. And in some cases, that employee will only go to that specific jurisdiction once. However, in other cases, the employee may go on a regular basis, for example, to the same foreign holiday home. Then the outcome of the Working Party 1 discussion that took place in February, it's good to note that delegates came to a common understanding on several key elements of the work. And the two most important to mention here today, I think, is that the shared views on the working definition as well as on the common scenarios to be addressed. And secondly, an agreement to prioritize the work on permanent establishment, which fully aligns with business concerns. With respect to PE, as we all know, and I think will be discussed later today as well, assessing a PE is highly dependent on the facts and circumstances of each case. So with respect to PE and scoping within the work related to PE, delegates considered that there's especially a need to look at updating the commentary with respect to home office PE, but also with respect to the term habitually related to the dependent agent PE, and looking at the application of paragraph 4, so the exclusions to PE. And then secondly, it was also considered to develop safe harbors with respect to temporary teleworking abroad, and especially to consider the link with profit attribution, as it's in no one's interest to recognize many PEs to which no or little profit would be attributable. Then looking at the future, we have a couple of meetings lined up this year. First of all, we'll continue engaging with our business stakeholders. Then also important to note is that Working Party 6 on transfer pricing will have a first discussion on global mobility in July of this year. With respect to Working Party 1, there will be another meeting in September during which the PE issues will be discussed again. And after that, we may organize a wider public consultation depending on the progress made. And this is all with the aim of including changes to commentary potentially as part of the 2025 update to the model. So that was it for my presentation today. I'll hand back to Angie.
Thank you, Yves, and we all look forward to the work that the OECD will do on these topics, which are very important. And I speak not only as a WP1 delegate, but really in general, it is an important topic. And we all want that the OECD continues his good work on it. Okay, next in line is a presentation by my very distinguished colleague of the same directorate of International Taxation, our Department of Regulation at the General Administration of Strategic Expertise and Support, Mr. Pierre, who is also the president of the task force on cross-border teleworking during our Belgian presidency. He has done a lot of hard work for this task force, and he will guide us through the work that has been done already, and specifically on Article 15 of the OECD Model Tax Convention on the taxation of wages and salaries.
Thank you, Angie. So I will present you the works of the task force on cross-border teleworking, which met 3 times during the presidency of the council. The starting point of these activities were the importance taken by teleworking and the creation of task force, conceived as an informal working group, so it was not an official working group of the council. The idea was to have an open discussions on this topic, so not to reach a binding agreement. As an informal working group, the member states were free to decide to participate or not, and we had workload, which is the need to have an accounting of the day's work in each state, and also the evidence that has to be provided of the presence in either state. Another con is therefore the risk of tax dispute, which is very much connected with the previous con. A risk of tax dispute not only between the taxpayer and the tax administration, but also between both tax administration. For the employer, that's the same administrative workload because he has to assist the employee in the provision of this evidence. For the employee, as a pro or as a con, depending on the circumstances, and it will be more discussed later, there is no synchronization possible with social security. As a con, we have the same administrative workload, the same risk of tax dispute, but also here, for him, the risk of loss of Schumacher benefits if the amount of wages or salary become too low in the state of the employer. So we assessed the rule which is currently applicable, and we also made an assessment of the different alternatives that can be contemplated. We identified 4 alternatives. The first one is the threshold rule. The threshold rule, the Article 15 remains in principle applicable, but with a certain degree of tolerance regarding teleworking, so which allows the employee to remain taxable in one state, being the state of source, and even he works for a certain number of days in the state in his state of residence. With this threshold rule, as soon as the threshold is exceeded, we fall back on the pro rata principle of Article 15. The pros and cons of this rule: first, for the state of residence, in principle, loss of tax revenue. For the state of source, it's the opposite, an additional tax revenue, and a better correlation between taxation and deduction of the wage costs by the employer. For both states, as a con, an administrative workload and a risk of tax dispute. So the same as with the current rule, because the same accounting of days has to be made and the same evidence has to be provided, because there is a need to check whether the threshold is exceeded or not. For the employer, sorry, but the same administrative workload. And for the employee, a lower risk of loss of Schumacher benefits, because its wages would, in principle, remain taxable in the state of source. And a better, a possible also synchronization with Social Security. As a pro, as a con, it's always the same. As a con, the same administrative workload, the same risk of tax disputes, but also here a limit to teleworking, because if the threshold is exceeded, that would entail a radical change in the allocation of taxing right, because it would mean that we would fall back on the Article 15 and the pro rata rule. Second alternative, identify an exclusive taxation in the state of residence. This is based on the existing examples of frontier workers regimes, but without any limitation based on the frontier zones. The pros and cons here for the state of residence. First, of course, it would mean for this state an additional tax revenue, a loss of tax revenue for the state of source, and here, of course, but no correlation between taxation and deduction of the wage costs in the state of source. But for both states and also for the employee, for the employer, this would entail a lower administrative workload because there would be no need anymore to have an accounting of days and an evidence of the presence in either state. For the employee, the same, so a lower administrative workload for him for the same reason, no risk of tax dispute for the same reason, and no risk of loss of tax benefit based on personal and family circumstances, because they would be entirely taken into account in his state of residence. And also no limits to teleworking. There is here no threshold. As a pro, as a con, always the same, possible synchronization with social security. Now, the first alternative, an exclusive taxation in the state of source. So it's just the opposite. It's pretty straightforward, of course. As a pro or cons for the state of residence, of course, a loss of tax revenue and additional tax revenue for the state of source. A correlation, a perfect correlation here between taxation and deduction of the wage cost for the state of source. What remain more comparable with the preceding alternative is the lower administrative workload for both states and for the employer. And also a lower administrative workload for the employee, no risk of tax disputes, no risk of loss of Schumacher benefits, and no limits of to teleworking, and always as a pro and con possible synchronization with social security. And the fourth and last alternative we identified is a taxation in the state of residence, but not here an exclusive taxation, a taxation that would be shared with the state of source, which would be allowed to levy a withholding tax, a limited withholding tax on the salaries paid to the employee. For the state of residence, that would mean an additional tax revenue, but also an obligation for this state to grant a tax credit in order to eliminate double taxation. And for the state of source, always a limited, by year, a limited correlation between taxation and deduction, only to the extent of the withholding tax. And as a con, a loss of tax revenue, but the withholding tax that would be levied in this state. For both states and for the employer also a lower administrative workload. And for the employee as well a lower administrative workload, no risk of tax disputes, no risk of loss of benefits based on personal and family circumstances, no limits to teleworking, and also a possible synchronization with social security. Of course, if the adoption of an alternative is considered, that would mean a change in the allocation of taxing rights with budgetary implications that could be the same in both states if the number of inbound cross-border workers is more or less equivalent to the number of outbound cross-border workers. But this balance would probably be unlikely, and in a more let's say, a realistic situation, well, it would be unbalanced. And in this case, the payment of a financial compensation should be, could be considered. A problem with the determination, at least the initial determination of this financial compensation, is the lack of data. Because we have mainly estimation in that regard. And also, we have also to bear in mind, at least from our point of view of states, that that will also mean an administrative workload, this payment from one state to the other, or an administrative workload for the employer if the financial compensation is a withholding tax instead of a direct payment between both states. Finally, the definition of teleworking. There is already a series of existing definitions, and my colleague Yves already mentioned one provided by the OECD. There is also a definition in the Social Security Regulation, and also definitions in a few existing DTAs. The use of this definition, well, it may depend on the drafting of the rule itself. It's not necessarily useful, but well, it very much depends on the drafting of the provision. And if where a definition is needed, there is a series of questions that remain open. Should we refer to teleworking, or more broadly to remote work? The difference between those two concepts is that the remote work doesn't require the use of a personal electronic device. Should we also refer to a default place of work, and should we also refer to other criteria, such as should we restrict the definition of teleworking to work carried out in the state of residence of the employee? Should we leave aside, let's say, the work carried out at the employer's premises, such as a PE that the employer would have in the state of the employee? And should we restrict the definition to work carried out in the home office? My last slide on the way forward. Well, at the end of these activities of the task force during the Belgian presidency of the Council, the participants were all agreed, including Belgium, that the priority should now be given to the activities that will take place at an OECD level, given well that it will be put on the agenda very soon. And also in order not to duplicate works and standards. But the participants all agreed at the same time that the task force should continue, maybe focusing on the taxation of wages and salaries, and also on the question of presence of a PE. And or if the OECD wants to focus more on the question of the presence of PE, maybe we should focus on the taxation of wages and salaries. We could have a regular exchange of views in that respect, maybe prior or after OECD meetings based on the documents produced by the OECD. But and also as regards the working documents, we realize that they could be further developed, but as they stand, we think they could already feed the discussions to be held at an OECD level, and also be used as toolboxes for the state that would like to address the issue of teleworking without waiting for the end of the debates at OECD level or in the task force. So thank you very much, and I will give the floor.
So I kindly invite the three panelists for the first panel discussion. So Mr. Pierre, Mr. Van Brussel, and we are also honored to have among us a wonderful lady from the tax law practice, Mrs. Anne de Rijmaker. So she works for the law firm Van den Dijk and Partners. Anne, if you could briefly introduce yourself further.
Good afternoon. So my name is Anne de Rijmaker. I'm an international tax lawyer and partner at the law firm Van den Dijk and Partners in Brussels. I'm specialized in international taxation with a focus on personal income taxes. And near to that, I'm also the chair of the Legal and Taxation Committee of AmCham Belgium, the American Chamber of Commerce. And with regard to this topic, I had the pleasure also to be a speaker at the hearings of the European Economic and Social Committee. So thank you for the invitation.
No, you thank you for coming. We will start with the first question. So the taxation of wages and salaries relating to cross-border teleworking is clearly a hot topic. We've seen it already. How important is it in practice? And will the relevance of this topic increase in the future, in your opinion? We will start with Mr. Pierre to answer the question.
Yes, thank you, Angie. But it's clear that since the COVID pandemic, it has grown in importance. And after the end of the pandemic, it has not returned to its previous level, but it's rather settled at a high level. It is likely that it will remain at this high level. Actually, these observations are based on more estimation and actual figures. But together with the estimation and also with the request made by various stakeholders in that respect, we think that it's sufficiently significant to be taken into account. In addition, if we remove the tax barriers to teleworking, it will further develop. However, if we consider a change of the current rule on allocation of taxing rights, we should also bear in mind that teleworking is not suitable for any kind of activities, and only activities that can be performed remotely are fit for teleworking. Of course, it includes most of the office work, but not many other activities such as healthcare, restaurants, factories, and so on.
Okay, thank you. Anne, Mrs. de Rijmaker. Yeah.
Well, I think from the practice side, it's for sure that we entered a new way for working since COVID. Due to digitalization, that's for sure. And I don't know if teleworking will increase, but it will certainly stay as digitalization will increase also. So that's for sure. From the practice side, I think that we see that a lot of employees continued working after COVID on an average of 2 days a week, let us say. And that effectively we need to see this, the facts, this is for sure, and that we need to see if Article 15, and specifically the physical presence condition that we still have for the moment in Article 15, does it needs to update it. And I think there is a lot to say on that, a lot of requests from the sides of employees and employers. If you are doing the same job from behind your computer at home, exactly the same as if you would do it at your desk at the home office in the other state where your employer is situated, and you only will do this from a teleworking site from your home if it's 2 days away, why would you change the taxation rights? There is a lot of questions on this, and I think this is something absolutely, if we look at Article 15, this is a time maybe to effectively change and adapt the rules to this new way of working.
Thank you. And then The next panelist, Mr. Van Brussel, you can tell us something more on the plans of the OECD, maybe, concerning that.
Thank you, Angie. Yeah, a lot already has been said, of course, and I think I can only echo business stakeholders do tell us indeed this is a pressing issue, and the increase in working from home, working from anywhere that happened during the COVID pandemic largely stayed. On the other hand, there also have been voices saying like, get back to the office. It's time to get back into the office, and maybe that resulted in the 2 days a week on average as compared to full-time from home. So I think it's still a bit of an open question, perhaps. And one issue we also, or many of us face, I think, is that is obtaining reliable data, not only on teleworking within the jurisdiction, because that's one given, but also on cross-border teleworking. And it's not always easy to extrapolate domestic data to a cross-border setting. We have to be very careful with doing that. So obtaining more reliable data is very important also for the future work on this to substantiate how big of an issue this is potentially. On future work at the OECD, Angie, because you asked. So the plan now at the OECD, at least at Working Party 1 on tax treaties, is to focus on issues surrounding permanent establishment. And then after that, we'll turn back to questions on Article 4 as well as on Article 15. With respect to Article 15, I think the main question I would ask is how likely is it that we can develop a one-size-fits-all solution given the broadly diverse context of certain jurisdictions and also differences in the flows of cross-border workers. And then also considering that there may be workers commuting between non-neighboring jurisdictions, that even makes the picture more complex. But what I do see a potential is, and that's what Harold covered also during his presentation, is that there's a wide range of potential solutions that could be adopted bilaterally to address issues. And potentially the OECD could further work on developing those solutions and provide them as template solutions for jurisdictions to further look at in a bilateral context. But that's, of course, very preliminary because the work at the OECD has just started, and the focus will first be on permanent establishment, and then we'll look at Article 15. Sorry for the long answer.
No, very good. Thank you. Does anyone have anything to add on this question? No? Okay, so we take away that it's very relevant to have reliable data, and of course also the question, is there really a one-size-fits-all solution? That will be probably difficult to find. Okay, the next question. A lot of reference has been made to the synchronization between social security system and the tax system, either as a pro or con for the employee, depending on the circumstances. How important is it, this synchronization between social security and the tax system, according to you? And what are really the problems in practice with the current systems in place? I would like to start with Mrs. de Rijmaker, with her view.
Thank you. Well, if we speak about employment, and I think a lot of people in practice know this, it's two aspects always. It's the social security aspects and the individual taxation aspects. They're always, if we're speaking about employment and cost of employment, aligned or need to be aligned or related at least. So for social security purposes, we have an EU regulation, 883/2004, and even since 1st of July of last year, 2023, in the framework agreement is foreseen that for an employee who is teleworking less than 50% of his time from the state of residence, under this condition and under certain conditions, he can stay under the social security legislation of the state of the employer. This has an advantage that you don't need to change from one legislation to another legislation. Now, of course, social security and taxation have different rules. And for tax reasons, of course, today we apply Article 15 since the end of the COVID agreements, the 3rd of June 2022. And it's for sure that now a lot of employees are confronted with the fact that as of day one, teleworking from home, for example, you have a tax switch. I mean, with that, effectively, you need to pay on a certain percentage or on the days that you are working from home, the taxes in the state of residence, and the others where the days can be effectively be proven as physically present in the working state, the state of the employer or taxing employer. This has a lot of complications in practice, absolutely. Payroll issues, you need two payrolls, who and where the withholding taxes need to be paid. There is issues, and that's PE issues, that's the most common, but that's for the next panel. But there are the double taxation issues. For example, a lot since the COVID agreement ended and where the tolerance was given that effectively the taxation could stay in the state of the employer. As of the 1st of July 2022, the normal application of Article 15, but a lot of employees and employers didn't realize all the tax implications that this caused. This means that person continued to work from home and effectively an employer with one payroll in the state of employer state what it was. This means that on 100% of the salary, for example, there was still withholding tax. Yeah. However, Article 15, this person now needs to pay taxes also in the residence state on the days spent effectively from home, for example. But this has double taxation problems because he needs to effectively try to get a refund for part of the taxes already paid in the state of an employer. And on the other side, he needs in his state of residence, like in Belgium, declare his worldwide income, ask for an exemption of taxation for the days that he can prove that he physically presented in the state of the employer. It's quite complicated and we see quite some tax disputes, honestly, in facts today. So I think we need to find, maybe it's a possibility to find at least also an alignment between taxes and social security. And not the rules, but the threshold of the 50%. It's maybe good threshold, honestly, to have this 50%, because if we're speaking that on an average, 2 days a week people are working from home, the 50% must be enough. And this means if a person then works less than 50% from his state of residence, most of the cases from his home office, the social security legislation stays in the state of employer, and also the taxation stays in the state of employer. This is, for simplification reasons, could be a good solution. If you would exceed the 50%, that's something else. Then you could effectively see, okay, also for social security, you switch, you need to be then under the social security of the state of residence, but also for taxation, you can say, okay, let's stay then taxable in the state of residence. So just to give an idea, there is a harmonization, or there is always a link with social security. And this is something that maybe needs to take in mind in a possible solution. Thank you.
Okay, thank you. Mr. Pierre?
Yes, thank you. I mentioned during my presentation the absence of synchronization between tax system and social security system as a pro or as a con, depending on the circumstances. This is before, at least from the employee perspective, we think that it can be a pro, for instance, where it is subject at the same time to the cheapest, let's say, social security system and to the cheapest tax system. But of course, it can be a con for him in the reverse situation. Obviously, it's not so straightforward. The benefits provided by the social security system have also to be taken into account in this assessment. And if we consider a modification to the rule on the allocation of taxing rights, and if the purpose, the objective pursued is an alignment with a social security system, there is if you have only one possibility, we have to adopt also the same system as already applicable for social security purposes and for the determination of the applicable social security system, which means a threshold of 50%, as my colleague said, with as a tax system applicable either the tax system of the state of residence of the employee or the tax system of the state of source, depending on whether the threshold is exceeded or not. But if other objectives are pursued, well, we can also consider other drafting, of course. So it's not necessarily the only way that would be available. So thank you.
Okay. Mr. Van Brussel, do you have anything to add on this question?
No, not really.
Okay. Then we go further with the next question. So we have seen the 4 possible alternatives that have been put forward also by the European Commission and also during the task force. Which solutions or solution would you prefer? And if you could also elaborate a bit on your ideas on the 4th alternative compromise solution of taxation in the state of residence combined with a limited withholding tax in the state of source. Would that be a good alternative for the current issues? Thank you. And we can start with Mr. Van Brussel.
Thank you, Angie. And yeah, I'll keep it very brief on this one as well. Speaking from an OECD perspective, at least we have 4 very, very interesting alternatives, I think, and it could be interesting to develop those further with a view of providing more guidance to jurisdictions so they can consider which one fits best in their specific context. And I think is important to provide that flexibility on that front because of the diversity in the teleworking practices that can take place, which is also highly dependent on the region we look at. So that's also to the benefit of the employees themselves.
Okay. Mr. Drijmakers.
Well, I think, as I just told in the previous question, I think the most important is that we find a kind of harmonization for the practice. That's the most important. Is it with the social security? I don't know, it could be, but I think it's a good solution. But the fact is, if we could save only in one state, is it the state of residence or the state of source? You can say for both, of course, the state of the employer, then you have the correlation effectively, as said before, between the taxation and the deduction of the salary, which is quite an important one. So I think that's also important. But the thing is, if you stay in one state, it could effectively reduce the compliance for employees and employers, the fact of the discussion of the proof of the physical presence, because that's eliminated. I think we can move forward by taxing in one state effectively. That would be great. Less administrative burden, etc. More legal certainty, because it is something that is requested by a lot of companies also. Give us some clear guidelines, effectively maybe with some thresholds, some safe harbor thresholds, then we knows everything is fine, no change of taxation system, no change of social security system, no PE issues, because you can even, of course, relate the social security, the individual tax and corporate tax if you have one threshold. That would be also a very easy one for the practice, if I may say it like that. But make it clear guideline rules and a kind of harmonization. If you use thresholds, please use one threshold. And now for the moment, we have bilateral agreements agreements with 34 days of tolerance, with 50, 96, and 40%. I mean, this is very complex, and I think we don't need to evaluate in that sense, but we need to find a solution effectively which can be used and eventually in bilateral agreements, but OECD is effectively, I think, the first who need to come up maybe or can come up with some clear guidelines of how to do it, as they did during COVID, because I think that went very good. 2020 and 2021, a lot of bilateral agreements have been negotiated on base of these clear guidelines from the OECD during COVID. So this is something that absolutely is needed for the practice very urgently.
Okay.
Thank you.
Yeah, so the call for more harmonization is clear. Mr. Pierard?
Thank you. From our point of view, we remain at this stage open to all alternatives, but especially with a caretaker government, we also need that the alternative considered would remain neutral from a budgetary perspective, and this could require up the payment of a financial compensation in case of tax loss. Well, and at the moment of making a choice, we could also take into account political considerations, because, well, for instance, if we take an alternative based on a taxation in the state of residence, in principle, that should be more let's say preferable for our budget, but that could be also less popular. So maybe that would not be the solution that would be preferable in the end. So, but it's still to be discussed and reflected. Thank you.
Okay, thank you. We will go further with the next question. That is, would it be useful, according to you, to come up with a common definition of teleworking, or more broadly, remote work? Mrs. de Rijmaker, if you could start.
Yeah, thank you. Well, I think, again, coming to the same message of harmonization, it's true that today, I don't think that a lot of people know what is then teleworking, what is remote working, what is digital nomads. I mean, everything, all these terms are used sometimes together in one, and it's not the same. Let us be clear. I think the definition of teleworking as proposed by the OECD is a very good one, saying that effectively you work from your residence state in the same way with personal digital devices, in the same way behind your computer from home, for an employer who is situated in another state. So I think this is very clear for teleworking. Okay, you can then say, is teleworking a subcategory of remote working? Yeah, I think so, because the teleworking, you have the specific teleworkers after COVID, as I said, who stayed 2 days a week at home working, and we see it in practice a lot. People who go for 3 days to Paris working, and then for the rest, on Monday and Friday, they work from home. Also, even outside of the EU, with the UK, you see that often going to London for 3 days and coming back for 2 days, teleworking from home. That's a different approach, and this new way of working, we see it in practice. This is the facts, and I think effectively a good definition, a common definition, would help to effectively find a solution for the specific teleworkers, if we call it, and that we see who are new since effectively the COVID crisis. So yes, and the social security, again, I think, but the definition with the OECD relies, I think, also with the definition of the social security a little bit, the EU regulation. So it goes in the good sense, and but again, I think it's absolutely important to have a very clear definition on teleworking.
Yeah. Thank you. Mr. Van Brussel, I think the example of going a few days to Paris a week sounds familiar for you.
Very much so, and thank you for the kind remarks on the definition. And as I said during the presentation, it's definitely a working definition, so there may likely be further changes. I think Harold during its presentation raised a good question on whether we should consider looking at what if that employee goes abroad but to the premises of the foreign employer that it has there. Should we specifically mention that as well? So that's something to take away from today, definitely. We will also have further discussions within Working Party 1 on that definition, but definitely our aim is to come up with a common understanding on which the further work and further guidance would then build, of course.
Thank you. Mr. Pierre, do you have anything to add?
Yes. No, just I would just like to point out that an agreement on teleworking does not necessarily require a definition of teleworking, and therefore a common definition of teleworking is not necessarily useful. It can be, but it's not necessarily the case. And it depends, as I said, on the drafting of the rule agreed on, and on the effects that we want to produce. And I would like to mention the example of the threshold rule that is included in the DTA concluded between Belgium and Luxembourg, in which the rule applies as soon as a Belgian resident employed by a Luxembourger employer works from Belgium or even from a first state, so from abroad. But on the contrary, I can mention another example of the threshold rule, which is included in the DTA between France and Switzerland, which applies specifically to teleworkers and to teleworking. And teleworking in this new threshold rule is defined in a rather restrictive manner. So it has to be carried out in the state of residence of the employee. It cannot be carried out in the premises of the employer that the employer would have in the state of residence of the employee, such as a PE in this state. It also requires the use of information on communication technology. So.
Okay, thank you. Then we'll go to the last question also, and that is actually on the way forward regarding this topic. And I would suggest, Harald, you can start again.
Yes, but I already mentioned in the presentation that now the priority will be given to the OECD. And once again, if the OECD mainly focuses on the question of the issue of the presence of a PE, the issue of the taxation of wages and salaries could continue to be dealt with by the task force. And of course, progress can also be made in bilateral negotiation, and without necessarily waiting until the end of these discussions, either at the OECD or in the task force.
Yes, thank you. Mrs. de Rijmaker?
Well, honestly, I think, and I don't want to put pressure on the OECD, but I think that from the practice, everybody is waiting for the OECD to take absolutely quite quickly an initiative in the sense of guidelines, in the sense of adapting effectively the commentary or whatever. Okay, it's maybe not binding, but it's useful because in the bilateral negotiations between state members, it can be used, and we saw that it worked in the past. So absolutely, I think if the OECD could come up with clear guidelines, could give legal certainty, and this could be applied then by the member states in bilateral agreements eventually, but at least that everybody effectively will be on the same line. And this is not today the case. And I'm speaking about the definition. If you have a bilateral agreement where the definition is different in one and in the other it's more strict or less strict, it's complicated to apply it in the practice, let us be clear. So the definition, but also the thresholds, that is today the big problem of today, if I may say. And I understand very well that there is a financial issue behind, that's for sure. But I think we need first to check what the rules are and then maybe check what the possibility of the compensation, the financial compensation between the states can be. We're living in this digitalization world, so we need to find a solution for the future. And I agree that the financial impact for states, some states can be huge, and especially for Belgium, but hopefully we will find then a good solution in the kind of a sharing revenue compensation method in order to find out. But again, I think the harmonization is important. There was a very recent EU report on the single market where from Mr. Enrico Lette, which said again, we need more harmonization also with regard to the free movement of cross-border workers. I think it's something that we need to think about this harmonization, and it goes further than only the EU. That's why the OECD is so important. It goes much further, this cross-border working, but the harmonization and the legal certainty that it will bring for employees and employers is very important for the practice.
Yes,
thank you.
Thank you. And Mr. Van Russel, anything to add?
Oh, maybe just to thank Anne for the very encouraging words to get back to work quickly, which we will do. We'll in full swing on this, I say. And our next discussion in Working Party 1 will be in September, as I've mentioned. However, we'll focus on PE because that is what business says is the most important issue for them, but we'll certainly come back to Article 15 as well, as it concerns many individuals directly, of course, and we also hear those voices from individuals directly. So that's something we keep in mind. So thank you for the kind remarks.
Yeah, if I may add, I think honestly, and it's a little bit of a challenge, of course, it would be maybe a missed opportunity if we would not, if you only discuss the PE issue of Article 5 without taking into account Article 15, because both are linked. I'm sorry, but if we're speaking today about cross-border workers, the PE issue is a very important one. And it's as well the corporate aspects as the individual aspects that need to be taken together. And if we're speaking, for example, about the threshold, a very good example is from Belgium with the Netherlands, a recent agreement on the PE issue. And I was very happy to see a little bit that the threshold of the 50% was used. And I think if we could effectively go further on this basis, that would be good. So the PE issue also linked with the threshold, if you work less than 50% from your residence states, from home or whatever, but from your residence state, that effectively the social security would stay in the state of employer, that you can align with individual taxation, that also there it's easy, you stay on the payroll with the employer, with withholding tax in the employer, and that if effectively less than 50%, there would be no PE issue. More in general, under certain conditions. But if we can make the link of these three, that I think would be the ideal situation, if I may say.
Okay, Yves knows what to do.
Yes.
Okay, I would like to thank you all for your very enlightening insights, and then we can go further with the next debate, and we very much look forward on the next steps that will be taken at the OECD level, but maybe also more general by country by country basis. Okay. Thank you very much.
Thank you.
And I now welcome the next panelists to the stage, which is the panel on the discussion on the taxation. Now we first have time only for one question, probably from the room, because we're running out of time, 1 or 2 questions. So is there anyone who has a question in the room? Sorry, the time was yeah, okay. Is there anyone who has a question here? There is someone at the back.
Thank you. Yeah, works. First of all, thank you very much for explanation and for the outlining of what steps have been undertaken already with regards to cross-border workers and taxation. This topic indeed is very hot, and I today probably represent one of the voices of the employers. And yes, we do need the guidelines, and we want to hear some updates, because employees who are in the cross-border situation, they do feel pressure and they feel a little bit discriminated, if I may say so, in comparison with people who work in the same country and live in the same country. So this is a huge positive step that the conversations have started already. The question, of course, is what are the timelines? When can we expect something which is touchable, usable, that can bring peace of mind to employers, employees, and perhaps also governments to avoid administrative burdensome? Thank you.
Okay, I think this question is for Mr. Van Brussel. Sorry, Yves.
I think so, although Harald may have something to share on other bilateral agreements on this specific issue that are considered, but happy to provide an answer here. And maybe after the question, could you maybe state your name and then who you work for, so we have a bit more more context? No, nothing personal. So on timelines, so next meeting in September, and then we are working towards including changes to the commentary in the 2025 update of the model. So that's next year. What's positive about changing the commentary in the model and not the provisions itself is that for some agreements, at least for some jurisdictions, that commentary can then be immediately used for the interpretation of existing bilateral agreements and existing provisions. If we were to look at changing to the articles themselves in the model, that doesn't do anything, right? It has to be in the bilateral agreement, so that would be potentially less effective. That is still an open question. There may be changes to the provisions themselves. There may only be changes to commentary, but we are also keeping that in mind. So on timelines, very concretely, we are working towards the 2025 update. I cannot guarantee that we will make something happen before that timeline, because we at the OECD don't decide, right? We are a member-driven organization, so all the member jurisdictions around the table have their say and are trying to come to a common understanding on what they can agree on that's going into the model and what is not going into the model. So hopefully that provides some comfort, but happy to take follow-up questions.
Thank you very much. My name is Christine Zaiseba, and I'm Global Mobility Manager at Delaware Consulting. So IT company, teleworking and remote working is heart of our company, actually.
Thank you.
Thank you for your question. Anyone else? No. Okay, then we will continue with our next panel, since we are already running a bit out of time. But thanks again for these three panelists for your very good insights, and give them a warm applause again. So now we come to session 2, the panel discussion on the evidence of that a cross-border worker needs to present. And I would like to welcome our two panelists for this panel to the stage already. So as we all know, the cross-border teleworkers risk being taxed in several states. So their state of residence and the state where they exercise their activity. So they have to rely on the provisions of the double tax agreements to avoid double taxation. But in order to benefit from these provisions, they normally have to provide the evidence that the conditions of the exemption provided for in the DTAs are fulfilled. So the DTAs, which divide the taxing rights between the contracting states, they are not intended to govern the burden of proof and the means of proof. This part of the procedure is so only regulated by the domestic law. In Belgium, the tax administration bears the burden of proof with regard to establishing the tax debt, but the taxpayers bears the burden of proof if they claim a deduction, reduction, exemption, reimbursement, or generally a more favorable regime. So the taxpayer has to provide proof of the material elements which give rise to this exemption. The tax administration will ask the taxpayer to prove that a salaried activity was carried out in one state or the other. So the worker who divides his salaried activity between the state of his employer and the state of residence in the event of teleworking will have to provide proof of the proportion of the activity in each state. And the written proof will generally be favored over the less reliable testimonial proof, as it provides it wants more objective data. So, but then is the question, how does one really provide the proof of teleworking? It seems quite difficult. There is also mentioning sometimes of geolocation tools, for example, but then there is, of course, the issue of privacy, GDPR. So within the task force, we saw a range of perspectives concerning the means of proof. Some countries emphasize the need for flexibility and practicality in most cases to accept some form of self-assessment and a reduced burden of administration for the taxpayers. But on the contrary, other participants or countries involved in the task force, they were more concerned with the risk of opportunities for tax avoidance or even tax evasion. And they advocate for formalized evidence provided by the employer's employees through comprehensive time records or really objective data. And Belgium is also more on the stricter approach. We have an example of a vademecum between Belgium and Luxembourg, which provides details on the types of evidence that may be provided by the taxpayers. But now we will continue with our two specialists. We have Jos Paukens, Secretary of ACV Frontier Workers, who is here. A warm welcome to you and thanks for coming, Jos. I'll let you introduce yourself a bit further.
Thank you, Angie. I'm Jos Paukens. When I'm in Belgium, when I'm in the Netherlands, it's Jos, so it's just the name. I work for the Belgian trade union, ACV CSC, cross-border working. I do this cross-border working for about 30 years. We deal with social security, labor law, and tax matters. And each year, about 3,000-4,000 declarations we fill in. Dutch declarations, income tax, Belgian personal tax, and the non-residents. So we have a large experience on this matter and a large of examples, also said in the first panel, where the complexity is to be situated.
Yes, and then next to you there is Mr. Ronald Vaassen of the Dutch Tax Authority, and we're very honored that you made it here today, all the way from the Netherlands. Thank you for coming. If you could introduce yourself a bit further on what you do.
Yeah, thank you, Angie. My name is Ronald Vaassen. I work with the Dutch tax authorities, more specific with the Knowledge and Expertise Center for Foreigners. And this office deals with non-residents, non-Dutch residents having a Dutch tax liability. And of course, we work closely together with the units in the Netherlands who deal with Dutch residents working abroad, as well as with the unit dealing specifically of Dutch residents working in Germany and Belgium. I work now for 3 years with the Dutch tax authorities, and before I've worked about 25 years with the Big Four firm, dealing with global mobility and advising clients about cross-border employments.
Okay, you seem perfect to be here. Okay, we will go further with our first question. So the first question, the issue of the burden of proof for the cross-border teleworkers is clearly also an important topic. And what are your general views to this issue, and how important is it actually in practice? How do you see it on a daily basis, actually, the problems that there are? I will start with Jos.
Well, you occur it very often. Of course, the Belgian tax administration has the right to ask for proof, but if you have a look the way they do it, it's quite intimidating for the cross-border worker. I've one example here. Someone gets a letter with 10 questions subdivided. It takes half a day to answer the questions, and then they ask you to prove it with documents. And that's not always a simple question. If I would ask you here to prove where you were in 2022, you can write it down, but try to prove it. So the cross-border worker always has the feeling he is targeted, and that they are asking things from him as he was was doing fraudulous declaration, and that is not always so. It makes it very complex, and you also see from the point of view of the tax administration a very fixed relation to the cross-border, not as a client. It is a dominant position, and it's very difficult to break out. And I once had one cross-border who had 400 documents to prove where she had been. Cross-border work already is quite complex. Other social security system, other labor law, 2 tax systems, the working state, state of residence, 2 declarations. And the most I see is the Belgian tax administration asking those proofs. From the Netherlands, I've never occurred it. They have more a client
Approach.
purchase, and that makes it quite different.
Okay, Ronald, your views?
Yeah, thank you. Yeah, well, basically, of course, it's really important. The taxation rights are based on the allocation of on the allocation of days where one has worked, whether from home or in the country of the employer, for example. So it's really important. It's also important to make sure that it doesn't become too much of a hassle for employees, employers, and even tax authorities. For example, it's a really important factor, the burden of proof for an employer or an employee to even consider or to accept a global employment. If it's too much of a hassle showing the proof, now Jos already showed us an example how complex it can be. Well, if that's the case, then people won't even consider accepting a cross-border employment. So again, it's really important to make sure that you can still manage to arrange for proof. And then another topic is, and it's already addressed before, the difference between the Netherlands and other countries, and that's the focus. Well, some countries really focus on anti-abuse to avoid abuse, where again other countries more focus on they start considering the willingness of an employee to be compliant. So that's a different starting point. So I think it's important to distinguish between the two. And like you already mentioned, the Netherlands is more in favor of the approach where we will take as a starting point that the employee is prepared, is willing, as well as the employer, to be compliant, and less focus on, well, it's very likely that the employee will abuse the system as such. Don't get me wrong, abuse is really a factor, so it's something to consider, but possibly it's too much. I'm not sure whether it's the proper English to overshoot the target, where we would establish or set up an arrangement, a procedure based on anti-abuse, and then the other group, the group more focusing on or more willing or being prepared to be compliant, would be affected by that system. So, well, I think we feel that, well, the better approach could be from starting point, well, let's assume that employees and employers are really prepared, willing to be compliant.
Okay, thank you. So clearly a different approach between Belgium and the Netherlands, and maybe the more considering taxpayers as clients, as you see it in the Netherlands, is a very different perspective to start with. I would agree with that. And then the need for simplification towards the cross-border worker. Okay, the next question. Which types of evidence are actually accepted for an employee wishing to prove his or her place of activity? Could you elaborate a bit more on that? Which kind of types of evidence are accepted, Jos?
On the Belgian side, all kinds of employment contracts, time registration, invoices, payroll statements, tax notices from the other country, etc. But you have to put it all together. And that's one of the problems, that even an employer's declaration on itself is enough. It is not enough. So you have to have other evidences, other documents to prove your physical attendance in the year. You also see that very often it is just a general approach, asking all these documents and just cut and paste. Always the same. There is no individual approach to the taxpayer. For instance, the cashier at Albert Heijn is treated the same way as the ASML engineer who travels around half of Europe. There should be more an individual approach and less complexity in the whole way of asking. But of course, you can have a lot of documents, but it's quite remarkable that, for instance, an employee's declaration is not accepted, as if the employer does not say how it has been, and he has no interest of giving you a false declaration, not at all.
Yes, okay, Ronald, because in the Netherlands the employer's declaration is accepted.
Yes, it is accepted, but not required.
Not
Because
required,
basically
yes.
we ask, well, we start with the principle that the employee knows best, basically. So the employee will declare a certain split, and we would ask for a sound travel calendar, stating hours or days where one has worked. Basically, if it's a sound calendar, and with sound we mean it's a neat, it's a clear overview, it's understandable, it's readable. It can sometimes be an issue, or kind of self-explanatory. If that's the case, that's only what we need. We even don't need confirmation of the employer. That's not necessary. Sometimes you get a confirmation, that's fine. It's always difficult well, how to deal with an employer's confirmation, because he said, well, that's one requirement in Belgium, but in the Netherlands, at least that's my experience from my previous life, that some employers easily just sign a statement, okay, just let me know where to sign. And that's also a kind of, well, maybe a false feel of security that then it's okay. But okay, we don't ask for it. We basically ask for the sound travel calendar. Mm-hmm. And only in case there are reasons to ask further, then we would, well, investigate things. And, well, of course, when are there reasons? Well, that's really depending on the file. For example, if one taxpayer is submitting 3 or 4 different travel calendars, or is basing his annual salary, his base salary on this calendar, and then his equity sourcing is based on a different calendar. That's strange. So then we would ask further questions. Sometimes a travel calendar is provided in a way of, I don't know, 40 or 50 pages. For instance, a chauffeur, he just has a printout of where he's been, all the hours he has worked. Well, that's not really accessible. It's not like we are then going to study the overview to see where he could have worked. That's also not accepted. So then we ask also for further information how to deal with it. And then when asking for further proof, that's the difficult point, of course. If one has been in the US, that's easy to show, to demonstrate. Well, like an employee has to provide document A, B, or C, and if that's not there, then it's not accepted. No, but often an employee can show different documents specific to the situation. And based on that information, we assess whether or not the travel calendar or the split claimed is acceptable. So it's less asking for specific documentation. It's really looking at the case at hand to see what we can do to, well, to approve or to accept.
Okay, thank you. So here again, we see a difference, a more
Yeah, so maybe I can add, and even when I was talking about chauffeurs, sometimes, well, I just said you can get a printout of 40, 50 pages. And sometimes it also helps to ask to the systematics of the way split is calculated. Because if you know how an employee or an employer has calculated the split on what systematics, that can also help to understand the outcome. And then you can check whether or not the systematics are correct by taking samples. But then you just take, I don't know, 10 days or so, or even 5 days. It really depends on the situation. But then you will use a different approach. That's also a method we apply if that would be the better way. Yeah. Sorry.
Okay, thank you. Yeah, no, but again, we see a difference, a more individual approach, I would say, in the Netherlands, and a more general approach in Belgium. Okay. So we go to the last question, which is, how do you see the way forward on this topic and the work forward? What could be possible solutions or helpful tools for the taxpayers in general? How do you see this, Jos, to start with?
I would say make it easier. Make it easier. Have more trust.
Simplification.
Why
yeah.
mistrust taxpayer? Why mistrust the employer? It's not necessary. Control it, of course, but also work with a tool. Provide us with a tool. Provide taxpayer with a tool so he can make his own calculation. It will make it easier to do the declaration, and it will avoid mistakes. It will avoid mistakes also conscious or unconscious.
So to add it in the declaration, an extra tool, okay. Ronald?
Yes, I basically fully agree. And then also start with the starting position, more trust towards the employee or employer instead of assuming that there will be abuse or fair risk of abuse. And also, well, related to that, accept that it's really difficult to have watertight proof that that's hardly possible unless we would chip people and to chase them up, to track them like that, but that's not something we, well, would prefer, I guess. So more flexibility, facilitate an employee and employer in the way they can provide substantiation for their position taken, and look at the case at hand instead of taking a standard overview, standard questions, and just mark the different, check the boxes basically. And one final remark maybe that works in the Netherlands is to make sure that within a country the way of working is likewise, is kind of a uniform way of working. So to make sure, well, in the Netherlands, the different units, that we communicate and that we are on one page, on the same page when dealing with these kind of files. And I think that's important too, because in practice we sometimes see if taxpayers, well, reach out and then ask, say, okay, well, we are in this and that country, but well, the local tax authorities refuse or do not accept the evidence provided. Well, then we have a kind of way of working throughout the country where it's dealt in the same way with the evidence provided.
So coherency overall is important. Okay, thank you. Then we now have time for Q&A. So are there any questions from the audience here for the two panelists? Apparently not. Are there any questions online? No. Okay, then it's clearly time for our coffee break. But first, a warm applause for the two panelists. It was very interesting. The third session will handle the permanent establishment issues related to teleworking. And to start off, my colleague from the General Administration of Fiscality, Nicolas Woto, is going to present the results of the task force under our Belgian presidency under this topic specifically. And he is also a panelist for our last panel. Thank you very much, Nicolas, to present the results.
I thank you for your presence and your interest in this topic. So, on the topic of permanent establishment and teleworking, which attracted a lot of interest, among the consequences of teleworking, there is the creation of a permanent establishment of the employer in the worker's home. Despite analysis, specific analysis in the OECD commentary of the Model Tax Convention, there remains considerable uncertainty as to the circumstances that could lead to the creation of a PE. So in addition to the normal work done at the OECD, Belgium has taken several steps to try to resolve these uncertainties and provide clarification. Among them, the conclusion of an agreement between Belgium and Netherlands on this topic. And during the Belgian presidency of the European Union, Belgium has led a task force regarding cross-border workers and teleworking, one of the main topics being the creation of a PE in such situations. So, what is a permanent establishment? Following Article 5, Paragraph 1 of the OECD Model Tax Convention, the term permanent establishment means a fixed place of business through which the business of an enterprise is wholly or partly carried on. So, as we see, there are three conditions. The existence of a place of business. The place of business must be fixed with a certain degree of permanency, and the carrying on of the business of the enterprise through this fixed place of business. A home office has normally a fixed nature and is used to carry on the business of the enterprise, but it will be only a place of business in the context of Article 5, only if it is at the disposal of the enterprise. To be at the disposal of the enterprise must choose the location through its worker for an extended period of time. It is primarily a factual test depending on all facts and circumstances of the case. To determine if a home office constitutes a PE, it will be the most important factor. The OECD has also examined the topic of the existence of a PE in relation to teleworking. There are two conditions in paragraph 18 and 19 for home office to constitute a PE. First, the home must be used on a continuous basis. And second, the employee is required to work at home by the enterprise. For instance, if the enterprise does not make an office available to the employee. It is to be noted that this requirement condition only exists for teleworking situation and not other potential PE. For instance, it will not be a condition if the enterprise uses the premises of another enterprise. But the requirement condition also leads to more questions for employers who decide to no longer provide sufficient office space to accommodate all their workers. For instance, in a desk sharing situation, are the employees required to work at home? Also, for workers who live so far from the employer's premises that they cannot use regularly the office made available to them by the employer, does it amount to a requirement to work from home? These questions are still not answered. It also appeared that during the task force discussions, there were considerable differences between the members of the task force in their approach to this condition. Apart from the disposal test, there are also the question of the activities performed by the worker at home. Because activities of a preparatory or auxiliary character do not constitute a permanent establishment, even when carried on through fixed place of business. So a home office, which would be at the disposal of the enterprise, will still not constitute a PE if it is only used for such activities. The OECD commentary mentions that the activities performed at a home office will often have a preparatory or auxiliary character, but we may wonder if it is still valid with the growing importance of teleworking. So the OECD commentary broadly defines in general the notion of activity of a preparatory or auxiliary character, but there is an agreement that the determination of what is of preparatory or auxiliary character in relations to activities performed at a home office remains difficult in practice. That the assessment is first and foremost fact-based and has to take into account all the facts and circumstances of the case, such as the core business of the enterprise or the role and function of the employee. So to resolve these uncertainties from the Belgian side and from the Dutch side, the Belgian and Dutch administrations have decided to conclude an agreement to clarify for Dutch and Belgian employers the particularly relevant elements to determine whether employees home working in their country of residence leads to the creation of a PE. The agreement is still based on the OECD commentary. There is, we stress the importance of the disposal test. The activities of a preparatory or auxiliary character are recognized to not create a PE, and all facts and circumstances are taken into account. Nevertheless, there are some features in the agreement, such as a 50% threshold, which has been cited before. So a worker who teleworks less than 50% of his working time does never lead to the creation of a material permanent establishment. There is also a distinction between three types of teleworking, such as occasional teleworking, which does not create a PE, structural teleworking, but with the possibility of working on site, which does not lead to the creation of a PE either, and finally, structural and compulsory teleworking, which constitutes a PE, as the two conditions mentioned in the OECD commentary are fulfilled: the use of a home office on a continuous basis and the fact that the employee is required to work from home. The category structural and compulsory teleworking also includes fact-based compulsory teleworking, such as when no workplace is made available to the employee by the employer, or the fact that the worker cannot carry out his work adequately or in accordance with the employment contract if he doesn't work from home. Finally, the agreement also gives some examples of activities which could depending of circumstances, be considered as having an auxiliary character, such as, for example, secretarial activities, internal accounting, human resources, or ICT support. The task force also examined the case of the dependent agent permanent establishment. So Article 5, paragraph 5 of the Model Tax Convention mentions that a PE is also created when a dependent agent acts on behalf of an enterprise that has an authority to conclude contracts in the name of the enterprise and habitually exercises this authority. For such PE, as the criteria do not require any material element, it will not be the fact that the location is at the disposal of the enterprise which will be of importance, but the contractual authority of the worker and the recurrence of this specific activity. And the term habitually implies a recurrence, but not as significant as the one required to the determination of a material PE. Concerning the attributions of profits to a permanent establishment located in a worker's home, there it is the Article 5 of the OECD Model Tax Convention that applies. There are no special rules in Article 7 regarding PE located at the worker's home. The OECD commentary also does not state anything concerning this specific situation. So as of now, in principle, the general rules as provided by Article 7, paragraph 2 will apply. And that concludes my presentation. Thank you for your attention.
Thank you very much, Nicolas, and thank you for being in our third panel. I now invite our other two panelists to the stage. Mr. Albert Radler is here also. He is a policy officer at the European Commission at the Directorate General for Taxation and Customs Union, Direct Tax Policy and Cooperation. Welcome. We're very honored to have you here. And then our next panelist, therefore the question remains if he still needs an introduction after being a professor in tax law for so many years and a true legend in the Belgian and international tax landscape. And I'm not paid to say this. No. And thank you very much for the honor of joining us, Professor De Broe, because I've heard also this is your last real public conference here. So thank you very much for joining us. A small applause for Mr. De Broe. So then we can start with the first question for our panelists. So what is your general point of view on the risk of creating a PE for the employer in the country where an employee is teleworking? And I would like to start with Professor De Broe for his answer to this question.
Thank you, Angie, and thank you for these very kind words, which were totally unexpected to me. So I'm a little bit re-establishing from the shock. Your question, or the answer to your question, is, and that is my very, very personal view, we do not need a world crowded with micro PEs, where there is little profit to allocate to and there's little tax revenues to be generated by. All this at the cost of high administrative burdens for tax authorities and taxpayers and a risk of double taxation and a lot of disputes. We have to go back to Article 7 because we are discussing Article 5, but we are discussing Article 5, the PE question, in order to apply Article 7. According to Article 7, the profit of an enterprise is taxed in the state of residence of the enterprise unless that enterprise has a significant economic allegiance, presence in another state. And that significant economic presence is a PE. only then profit of that company will be taxed in the other state. Based on the assumption that if there is a PE, then that company takes significant benefits from infrastructure public services of the other state. Now, in my view, that strong economic connection with the other state is normally not present if one or a few employees of a resident of an employer in one state are working in the other state in home offices. PEs should be retained for more exceptional circumstances, in this case here of home offices, and I assume that we will discuss this later today what these more exceptional circumstances are. We may not forget that discussing about PEs is a very challenging academic discussion, but we all do that to allocate profit to the PE, and allocating profit to the PEs is a difficult question, certainly here in that area. And we'll not go further on that topic because I understand that there is a question coming on transfer pricing, so I leave it here.
Okay. Mr. Radler?
Yeah, well, thank you very much for the invitation. Well, if there's a risk, yes, definitely there's a risk. No doubt about that. There's too much discussion on that. That we have here this panel on this issue is a clear sign that there's a risk. And I only have to remind the discussions we had at the stakeholder day at the OECD, where business community clearly stated this as the most pressing issue, the need to eliminate uncertainty about this issue. On the other hand, we are following up this question, and may I simply ask you the question to the crowd. Does somebody already had issues about this permanent established issue? Did you already have a tax assessment? So if you raise your hands. I see 2, 3. 3. Yeah, okay. We had discussions. We were familiar with that. We heard that this was in the cooking, but we follow this up, and the question now is, what can we do? I only want to recall that we had been in technical discussions with member states. One member state urged us to take this up and have technical discussions. We had sent a questionnaire to member states on the question whether there is a PE, and the replies were, well, we got the full range of replies. We had member states who said, you cannot have a permanent establishment if you work from at home in your private premises. Then we had few member states who said, yes, home office, more than 25, definitely. There is a de facto disposal if you work from home for your company. And the vast majority said, it depends. You need to look into the circumstances. Each case has its own merits. So difficult question. And we moved on and asked, well, what is the role, what the Commission could play? And was mixed again. And I think there is a overall agreement that the OECD is a good place to discuss this. It's a global issue. It's not only a EU issue. It's a global issue, and I'm very happy that this that the OECD actually takes it up. On the other hand, is there any role for the EU? Yes, there is. It also had been asked by few member states, by certain member states, to look into the issue, and it is here to confirm that we as Commission, we are ready and willing to take any form of coordination to take this subject on. Thank you very much.
Thank you, Mr. Radler. Nicola?
Thank you, Angie. Of course, for the employer, there are several risks. First, the risk of taxation, of course, in the state of residence of the employee if a PE is created. The main concern in our view is the uncertainty of businesses regarding the application of the tax by the tax administrations. And so the solution should above all aim to dispel this uncertainty. There is also, as mentioned, a risk of creating an excessive administrative burden, which would be the case if each home office would create a mini PE with the need to attribute profits to each of these mini PE. The Belgian tax administration shares this concern, and the creation of a PE in case of teleworking should be a rare event, subject to several conditions, as clarified in the Belgian-Dutch agreement. The fact that the teleworking must be structural, more than 50%, compulsory, that the activities must not be of a preparatory or auxiliary character. However, there must, of course, be a balance with these concerns on one end and the risk of tax abuse on the other end. For instance, a business which would normally create a permanent establishment in a foreign state to develop its activities there by opening an office could be tempted to avoid it by instead using several home office of these employees in a state, and so we want to avoid that as well. So there needs to be a balance.
Yes, thank you. Then we go further with our next question. So the disposal test is very important, as Nicolas clarified already in his presentation, but the interpretation of at the disposal of the enterprise remains unclear. Opinions within the task force varied regarding whether the concept of at the disposal of is sufficiently described in the OECD commentary. And what is your point on the view on the description of this concept? If you could start, Nicolas.
Okay, for the disposal test in general, as opposed to the disposal test in case of teleworking, the OECD insists on the following condition: the effective power of the enterprise to use the location, even without any formal right, the extent of the presence of the enterprise at that location. The location must be used for an extended period of time, and the activities that the enterprise performs there. And the OECD provide also several examples in the commentary. But as this is in numerous cases the most determinant factor to determine the existence of a PE, I think that even if the general concept is adequately described, clarifications would still be welcome. For instance, I'm thinking about the concept of an extended period of time, which could use some more details than the actual ones.
Okay, thank you. Professor De Broo.
At disposal, is the home at the disposal of the employer? The answer is generally no, because normally the employee has control over his home. He decides freely how he's going to use it. He should not give access to his employer or staff of the employer to his home. The employer cannot impose conditions as to how the home is to be equipped or furnished. So generally the answer is it's not at the disposal of the employer. It could become at the disposal of the employer if the employer has control over the home of the employee. That should, in my view, be exceptional, and it supposes that there is an obligation imposed by the employer on the employee to use his home for activities, for employer's activities. Now, from a legal perspective, there is at first glance here a kind of a problem, because under EU labor law, I'm not a labor law expert, but I've been speaking to labor law experts. Under labor law, European labor law, the telework is voluntarily. So it means that if we talk about a legal obligation imposed by the employer on the employee, that there must be an agreement between the two parties, which is included in the job description of the initial contract. So when an employer hires a new employee, he can deviate from that voluntary rule by imposing teleworking to that employee at a specific place, his home probably, for a specific time period. That then would be an enforceable legal obligation. That same European framework on teleworking also allows employer and employee to change existing contracts and provide teleworking, and I think under these conditions, then again, there could be a legal obligation, but parties may at all times terminate that telework and go back to the ex-ante situation. So that would the minimum that need to be fulfilled, a legal obligation to carry on telework. Of course, next to that, as Mr. Watteau has already alluded to that, there can be de facto obligations where the employee lives too far from the workplace of the employer and never works at that place, or where the employer simply does not provide any office space to the employee. Maybe may I just add to that in my view, I think the rulings which have been issued by the Belgian tax authorities, and there are quite a few, I think 7 or 8, are, in my view, very reasonable rulings, or rulings giving a very reasonable interpretation to at the disposal, because on top of that requirement of legal or de facto obligation, the ruling commission requires that the employer has reserved a right of access to the home, that the employer can forbid the employee to sell his home or terminate the rent of his home, or at least that the employer should agree to such acts, and the fact that the employer has a determining influence on how the home office is furnished or equipped to carry on the activities. I think these are all more facts that show that there is that the employer has control over the employee's business. But in all these rulings, the 7 rulings I think that we examined, none of those conditions was met. So there was no PE.
Okay, very interesting. Mr. Radler?
Yeah, well, if I look back into my first steps into international taxation, a PE in Germany, home office never at the disposal of an enterprise, never. Very clear. Huh? So if you have somebody teleworking from Germany, you cannot have a PE. I think I saw something similar in the Netherlands. And now, surprisingly, I take note of what Luc de Broek just said about the necessities of the employer. We look a little bit south of Germany, and normally a country which has a lot of similar traditions like Germany takes the complete different way and simply says 25% of home office is de facto at the disposal of the enterprise, and therefore clearly a PE, inbound, outbound. This is their Austrian approach, where also was cited that you could have issues in mismatches. So this could also be part of a tax planning. So this is surprising. Shows that although you have a common text that member states or countries can differ, can have different interpretations for that. So this is the current status, and would be good to have something clearer on that issue and a more harmonized, more coordinated application of the issue. Thank you.
Okay, more harmonization again. And Professor De Broek, you want to add something?
May I just add one thing? I think that the discussion which the country you mentioned on the 25% is not the right discussion, because there are two things. There's the occasional use of the premises, and that's where the 25 or 50% belongs to. And there's the issue of an employer having control over the home of the employee. So you can perfectly work 25% or more at home with your employer not having any control right over your home.
So true. Okay, we will now go further with our next question, which is about the requirement condition. So the employee is also required to work at home by the enterprise for the home office to constitute a PE. And among the participants of the task force, there were considerable differences in their approach to this requirement condition. Some express practical difficulties in applying this criterion. Others consider that the requirement condition is fulfilled when the employer has accepted that the employee performs part of his work at home. And then there are others who oppose the concept entirely. So how do you stand towards this requirement condition? And a specific question also about the case that has been described in practice by some MNEs. For example, that highly skilled employees or the higher managers choose to work abroad, for example, 3 months, to be closer to relatives or back home. Do you consider that these situations can give rise to the existence of peace? And I would like to start with Mr. Radler on this question.
The requirement to work at home. Well, we had in the task force a lot of discussions on that, very different views on that, which shows that what was when it was drafted was with a very good intention, but maybe at that time was a different time where telework was not so spread, and maybe these were not the words which fit. And I suppose OECD would look at it and, if necessary, make another, suggest another drafting, make it clearer. This is what I would suggest. With this special case, if you have a 3-month stay to be closer to a certain relative, for my taste, it is rather clear-cut. We have a permanent establishment. A permanent establishment requires a certain permanency, which starts as from 6 months. So for my taste, we would not be within the scope of a permanent establishment. This is, I think, a quite clear case.
Okay, thank you. Professor De Broo?
I don't have anything to add to that. I discussed the requirement question in my previous, under the previous question on the legal obligation, de facto obligation, where we should start from. And I fully agree with Mr. Redler that the gentleman working 3 months at home close to relatives is not constituting a PE, even if he is the highest manager of that company.
Okay. Mr. Watteau?
So on a theoretical level, I'm still a bit perplexed when I see that the conditions put by the OECD for the creation of a PE in case of teleworking are different than in other situations, as this requirement condition does not exist for the creation of a PE in other situations than teleworking. Nevertheless, on a pragmatic level, we see the goal here, which is not to create numerous PE for teleworking situations, which are fundamentally used by the employee for personal reasons in the vast majority of cases. And so we share the objective to not create PE in such situations. So in the Belgian-Dutch agreement and in general, we have followed closely this requirement condition to precise the Belgian position, the position of our tax administration on this matter, where the only category, such as in the agreement we have with Netherlands, where the only category of teleworking which creates a PE is the one which is one structural, but two compulsory. So, and I agree that in the situation described, namely high-skilled employees or managers choosing to work abroad for example, 3 months, there would be no creation of a material PE as the employee or manager has normally the possibility of working on the employer's premises but chooses to work abroad for a personal reason. Also, if it's a one-shot, normally the short duration of the stay would also mean that the permanency condition would not be met either.
Okay, thank you. We will go further with the next question. So activities of a preparatory or auxiliary character do not constitute a permanent establishment, even when carried on through fixed places of business. The OECD commentary mentions that the activities performed at a home office will often have a preparatory or auxiliary character. But do you think this is still valid with the growing importance of teleworking? And I would like to start with Professor De Broel.
Why do we have the exception for auxiliary and preparatory activities? And I think we mainly discuss auxiliary activities here, which are support activities to the core business. There's a good ratio for that. That is that these activities are too remote from the actual realization of profits by the enterprise to be able to allocate a significant amount of profit to that fixed place of business. So it's too marginal and difficult to allocate profit thereto. So are activities carried on at home offices auxiliary or not? I think that's a factual discussion that will need to be addressed on a case-by-case basis. Likely they include administrative support and secretarial activities, back office, call centers, the list of activities which are mentioned in Article 5.4d, purchasing activities, collection of information, market research, lobbying, you name it, ICT support, HR, that could all, in my view, be auxiliary, but again, don't generalize. Of course, what we should bear in mind is that even if an activity at first glance is a support activity, according to my list here, that is no longer the case if that activity forms part of the core business of that enterprise, i.e. if you are an ICT company and your ICT people work at home, these activities are no longer auxiliary. And then maybe I would like to add one more thing on management activities. Management activities are not auxiliary and preparatory, I think for very obvious reasons. So they cannot enjoy the exception. And then the next question is, what are management activities? I read a German case decided by a lower court a few years ago saying that handling paperwork and drawing up invoices and overviewing contracts is a management activity. I doubt whether that is correct. The case is under appeal. I doubt that is correct. Management activities, in my view, are functions which are carried out by board members, by highly ranked executives, employees that have a day-to-day leading management function for whatever nature. And then, and that's the reason why I would like to add that point here, there's the next question, is that there is that list of PEs, which is included in Article 5.2 of the OECD Model Convention, mentioning a place of management as a type of PE. And some countries believe or take the approach that because it is mentioned as a place of management, that place of management is ipso facto, I would say irrebuttably, a PE. And I don't think that is correct, because Article 5.2, the function of Article 5.2 is to list examples of PEs. And the home office, the office, by the way, is also mentioned there. So if we would say that an office is a PE, automatically we don't need to have the discussion on the home office. So what I would like to say here is, if management is involved, you still have to go through all the steps and see whether the person carrying on management functions at home is really having or has really put his home at the disposal of his employer.
Okay, very clear. Mr. Radler?
Yeah, there's not much to add. Simply to stress that if preparatory and auxiliary activities would lead to a PE, then you would have the proliferation of micro-permanent establishments, and I think it's overall agreement that it is of no interest for nobody. There is no additional tax revenue, and it is for all participants, for all stakeholders. It is a drastic increase of compliance. So if there is a PE, it should be reserved for the cases which really merit it to be one. Hola, thank you.
Okay, thank you. Nicolas?
So to come back with the question, if the activities performed at the home office will often have a preparatory or auxiliary character, from my point of view, this position, which was taken in 2017, is really linked with the pre-COVID world where teleworking was more incidental or intermittent. At the time, it seemed more adapted for such auxiliary activities, but with the growing development of teleworking and the fact that numerous people work from home for extended periods of time, it is difficult to argue that in all these cases, they will only perform auxiliary activities. Furthermore, from the Belgian point of view, the possible creation of a PE will only be examined if the employee works from home more than 50% of his normal working time, given the threshold in the Belgian-Dutch agreement. In that subset, it will of course depend on the function and role of the employee, but I think that it will often happen that the activity performed at the home office will be more than auxiliary activities. And so in these cases, it will need to be examined on a case-by-case basis.
Okay, thank you. Then we go further with the next question. So we all, and Nicolas just mentioned it also, the Belgian-Dutch agreement with the 50% threshold, where someone who teleworks less than 50% of his working time does never lead to the creation of a material PE. Do you think this agreement really constitutes an example to be followed more widely? And can you mention other existing agreements that have also very interesting elements? I would like to start with Mr. Radler.
Yeah, well, I consider this to be very promising. I think it's surprising and very, very promising. This is also reflected in the higher interest the agreement had in the task force. We are following up this very, very closely. So trying to get informed about how this agreement actually crystallizes in practice. Up to now, I understood that the practical experiences are still in the cooking. It's too early to draw any conclusions. But we will follow this up, and in my view, this could be that it could serve as a best practice, or even as a blueprint for other member states. What is very interesting is there is a very easy criteria, the one of less than 50%. If you work less than 50% in home office, you don't have a PE, which is very easy to understand, very easy to apply. Is it kind of an option if you go beyond 50% that you then go into the risk of having a PE? Difficult to say, but it's a very simple approach. And then you also take out the preparatory and auxiliary activities so that you in the end have the persons in home office who actually take higher positions, management positions possibly, and actually are to a large extent in the home office, not the office. So this reduces the number of possible or potential PEs to a number of cases which merit it. And again, the big advantage is we are able to avoid micro enterprises, micro permanent establishments, which makes it very difficult and very burdensome due to the high compliance burdens. Thank you.
Thank you. Professor De Broo?
I can only agree with that. I think I welcome it very much. It's a very reasonable interpretation of what is incidental or non-incidental homeworking, i.e. the 50% test. It's a very reasonable interpretation of what at the disposal means. It's nicely in accordance with the Social Security regulation to which Mrs. de Reemaker, sorry, referred to earlier today. So tax and Social Security are aligned. It really reserves the permanent establishment, I think, for exceptional circumstances, also because it excludes auxiliary activities, be it that it's hard to determine auxiliary activities. And I can only hope that Belgium continues to try to negotiate these arrangements with other countries where the issue is relevant, I would say, probably neighboring countries in the first place. And I would also suggest the OECD, when it revises, I hope the commentary, not the text, the commentary on Article 5 to make a sample clause, to make a suggestion, sorry, for a sample clause where there is or no PE, and that inspiration is taken from the Belgium-Dutch agreement.
Thank you. Mr. Otto?
First, I want to thank my distinguished colleagues for the kind words about the agreement. And I want to precise that even if it's a bilateral agreement, it is normally the position of the Belgian administration also with the other countries, regardless if there is a future more precise agreement or not. It can be, we will use, as the text is the same for Article 5, we have no reason to not use the concepts that are described in the agreement in a different way with France, Luxembourg, or Germany than with Netherlands. That being said, to our knowledge, the Belgian-Dutch agreement on the interpretation of Article 5 in case of teleworking is the only one existing on this topic. We feel that such a threshold is reasonable, that it provides clarity and ease of use for the concerned parties. And so we are, of course, favorable if it would be followed more widely. During the task force discussions, the qualities of the threshold were recognized, but most members considered that the amount of time teleworking was not a decisive criterion and mentioned that they prefer to assess specific situations by taking into account all the relevant facts and circumstances. So we are, of course, as mentioned, open to an extension of this threshold on an international level, but it is, of course, more difficult to reach a consensus on such matters on a multilateral level than on a bilateral one, like for Belgium and Netherlands. Thank you.
Thank you. And I've seen Yves taking a lot of notes, so he will go home with a lot of work. But thanks again for being here. Okay, the next question. So, as we've seen today, the interpretation of the rules that define the existence of a PE is to call blurry at best, but the non-compliance in reporting the presence of a PE can trigger penalties and disputes with respect to the profit allocation to the PE for employers and even the possible follow-up transfer pricing issues. How do you stand towards these possible consequences, and can you refer to examples you have encountered in practice? Should the issue of profit allocation to the created PE by teleworking be one of the priorities to be treated at the OECD level? And regarding transfer pricing issues, Mr. Van Brussel, Yves already told us earlier today that it will be on the agenda of WP6 in July, so very soon. So they are clearly working on it. I will first give the floor to Professor De Broe.
Your question was, did you have cases or encountered cases of PEs and allocation issues? Yes, I've been a practicing lawyer for 40 years and I have been involved in PE discussions. And I always like these discussions because you have hard fights with the tax authorities trying to prove the presence of a PE. And then at some point in time, I said, I rest my case because now it's up to you to allocate profit to. And if you do that in an arbitrary way, which happened many times, then the assessment risks to be annulled. Sorry for being a bit cynical. That is what is going to happen here as well, of course. How are you going to allocate profit to a home office PE? The AOA is at first glance not easy to apply. Maybe yes, the functions, that is what the employee is doing at home, but assets, risks, difficult, I think, to do. So in the end, what will happen? That we will probably use the cost plus method and then have a nice discussion on the benchmark. Should it be 8%, 10%, 12%? Nobody knows. You have cut out the auxiliary activity, so anything below 8% is probably a bit too low. So you add then a profit of, let's say, 10%, that if the employee earns 100,000, there's 10,000 profit to be allocated to, and you tax that at 25%. So that's a marginal amount of tax revenues. And that at the cost of uncertainty, because is the other state going to agree that there is a PE? First question. Second question, if it agrees, is it going to agree with the profit that has been allocated to that PE? Result, double taxation, disputes in national courts, MAP, arbitration, you name it, and a lot of administrative cost and hassle for all parties involved.
Okay, that's clear. Mr. Botto.
So, as I mentioned before, the goal of the Belgian tax administration is not to create numerous mini PE in case of teleworking. And so this seems more a case of concerns for the future by employers than numerous cases brought in practice. So we have not encountered these before. And with the Belgian-Dutch agreement, we feel that the creation of PE in case of teleworking should be a rare event, and this is the goal. The priority was concerning your second question, the issue of profit allocation to be one of the priorities to be treated at the OECD level. I think that's already the case, as I understood by the presentation of my colleague. But I don't know if it's needed to have specific rules regarding the allocation of profit in such PE, but it could be useful to see if there's a preferential method among those who exist now. Thank you.
Okay, thank you. Mr. Raper?
Yeah, there's not much to say. I'm not a transfer pricing expert, but what everybody told me, this is an issue which should be avoided as far as one can, and leave this profit allocation to the cases which really merit to be taken up to this level. Again, we need to avoid micro enterprises which only have increased the compliance burden. Thank you.
Thank you. And then we have another issue that wasn't treated during the task force, but it could become a more relevant issue in the future, namely the issue of the digital nomads. So you have people who go work across the globe and 3 months there and a month there, and they go couch surfing, some of them even. So the question is, how would you see what is your point of view on this issue, for which our current income tax system clearly is not suitable yet? I would like to start with Mr. Radler.
Yeah, interesting subject. We just had colleagues from DG Ample coming over to us for another initiative, and they presented it as a digital nomad issue. And we started discussing, and then we found out, well, it's not about digital nomads, it's about cross-border teleworking. So I refer to the discussion we had on the definition. What is a digital nomad? What is a cross-border worker? What is a remote worker? And a digital nomad normally is a person who works from various places, short-term, without having a domicile, without having a residence, and moving from one spot to the next. I understood that many more normally younger people, they like to move with the sun. So they move from one spot to the next one. And from an intra-EU perspective, we have persons, citizens who move to another, who go to another country, to another member state to work from there. I'm very happy about that. They exercise their free movement. So very good. This is why we are there. We had discussed this with member states. Again, we had a questionnaire trying to get a feeling on the scope of the issue, and it's very difficult. It's very, very difficult to have data on this. There's always this big fear, big risk. Is it possible? To now, I don't know. Is it possible that you move from one country to the next one and you are without residence? No tax liability nowhere? You're a global non-resident or EU non-resident? Does it work? Or are you so much bound into the whole system with a bank account, with VAT invoicing, with social security, with I don't know what, that you have to have somewhere some kind of link? I don't have the answer up to now. And to what I know, or to what I see, or from this issue up to now, is that there are digital nomads. We also have member states who actively want to attract digital nomads to come to their countries, to the member states. But the numbers are rather low. We don't have numbers on that. There's no statistics available, but the numbers are low. Our member states asked us to continue to look on this issue. What is another issue is the digital nomad visa. And here this is different, because a digital nomad visa, we have certain member states who have introduced that. This is not about intra-EU free movement. It's more a work permit. It's immigration law, because digital nomad visas are addressed to third country nationals to come to a member state for a certain period of time, normally 8 months, 12 months, sometimes renewable. And here we have numbers. And again, the numbers are low. We have, for 2021-22, I remember for Croatia, we have 600 persons, of which 200 Ukrainians, 200 Russians. We're from Estonia, the e-residency scheme, low numbers. Italy, I think it was around 2,000. So the numbers are all in all still very low. Again, for the digital nomad visas, it is about more immigration, that people come to the country and actually work there with a clean sheet. Interesting to see how this evolves. We follow this up. Thank you very much.
Okay, thank you. Professor De Broe?
Yeah, thank you. For me, it's first and foremost a residence issue, of course enhanced because of the teleworking issue. I assume that these people are single or couples with no or very young children who leave Belgium, for instance, and move to sunny places with good surf conditions. So Algarve, Fuerteventura, Basque country, Spain, Portugal, Mexico, I've been told, never been surfing in Mexico. So these are the countries where they move to. Malta also. I was in Malta, surfing conditions are not good. And yeah, in the first place, the question is, do these people become residents of these surf countries because they are there for 2, 3, 4 months? That's the first issue. Now, assume that they are residents of, let's say, Mexico in my example, and the person has left Belgium. He or she may end up in a dual residence conflict. And then the question is, of course, has Belgium any interest to fight that case? Because either the person is an employee of a Belgian company, for instance, working in Mexico all the time, the taxing rights are with Mexico because that's where he's working for a number of time, then exceeding, of course, 183 days. Or he's a self-employed IT person and if he works all the time in Mexico, I guess he has a PE in Mexico. So even if there is a dual resident conflict, there is not a lot of interest for us to fight for these people. I have a very nice case, but I'm not going to go into it because we are running over time, I've seen, of a Belgian resident who is a manager of a Belgian company, a one shareholder company, who has transferred his residence to Mexico. And then the next question is, what happens to the residents of the company? But I'm not going to do it in the interest of time.
Cliffhanger, okay. We're going to Nicola.
So the topic of digital nomads for us is less of a priority as the number is rather low, as mentioned before. Furthermore, concerning the issue of the creation of a PE, it is necessary that the place of business has a fixed nature, which will normally not be the case with digital nomads, which do not stay sufficiently long in a place to fulfill this permanency condition. And also it would be necessary that the remote working was compulsory, and again it will rarely be the case for such digital nomads who normally made the choice themselves to work from abroad. So it seems like a minor issue as of now. Thank you.
Thank you. And then to conclude our last question, in general, how do you see the way forward on this issue of home offices PE? And I will start with you again, Nicolas.
So as was mentioned in panel 1, the creation of PE in case of teleworking is on the agenda of the OECD WP1. The allocation of profits to a PE in case of teleworking will also be discussed shortly. In view of this timing and taking into account that these issues relate to the OECD Model Tax Convention, I think that the priority should now be given to the discussion that will take place at the OECD level. The ideal solution would be to have a consensus on the OECD level, which could include a more detailed commentary at the level of the most fundamental concepts in the context of teleworking. For example, the requirement condition, a more detailed definition of preparatory or auxiliary activity in this context, etc. And given that it is the internationally preferred source for the interpretation of double tax agreement, if this is not possible, specific agreements, like bilateral ones, can be concluded, and they have also the usefulness of being able to go further in the definition of concepts.
Okay, thank you. Professor De Broe?
We heard that the OECD is working on the issue, and of course we should welcome that, and I think they should clarify matters as soon as possible. And I fully join the idea which was suggested earlier by Anne Reemaker, i.e. that the OECD should not look at the issues separately. There's the issue of PE, which we're discussing right now, but there's the issue of Article 15, and I don't think you should see these two in isolation. In my view, they should be combined, and in my view, there can even be solutions worked out that satisfy both Article 15 issues we're discussing and 7 issues we discuss. I would call upon the OECD to show great reluctancy to lower once again the PE threshold for the various reasons that we have mentioned here before. If I may draw a parallel with what happened with Article 5.5 and 5.6 when they were amended by the MLI to make dependent commission agents becoming permanent establishments of their foreign principals. Several tax authorities in several states do not know how to allocate profit to these PEs. There is that local commission agent in, say, Morocco, and he earns a commission fee, which is at arm's length, and he's taxed on that. He has always been taxed on that. But since the MLI, that foreign principle, the Belgian principle, now has a PE in Morocco, and they simply do not know how to allocate profit to. So again, very nice academic discussions at the OECD, and technical discussions going on for a long time, leading to no practical result. And I think, I'm afraid that something could happen here in the same way. And I would like to close my presentation with a philosophical remark. That is that each time that we change tax rules, we should ask ourselves, are we making the world better now? And I'm afraid that if we lower the PE threshold for home offices, the answer is we are not. And that is my last statement in an official presentation.
Okay. Okay, Mr. Radler now.
Well, very briefly, I think it's already a good step that it is now clear that OECD had taken over the issue for PEs. It's a global issue, and therefore fully agree with that. That is the right place to discuss that. With regard to the issue in general, we have seen bilaterally certain movements. We have seen the number of days which had increased. We had seen unbelievable progress in the field of social security. So from a tax point of view, this is really remarkable to what extent social security is able to adapt to new situations in a very short time period, having all member states on board and also third countries, the EFTA countries. Then we have already seen some very interesting bilateral double taxation conventions. If we look to the new double taxation convention signed between Switzerland and France, which introduces a 40% threshold. So there had been progress. Now, if I look into the Benelux region, I'm quite amazed that between Germany and Netherlands and Belgium, there is no remedy, there is no relief for cross-border teleworking. The feeling what we get back, or the reaction we got back, is that for both the employees and the employers, the other side of the border is a no-go. So you lose as an employee living in Germany. If you want to look for an employer, everything which is beyond the border is of no interest. And this issue is for sure, from a perspective from Berlin, not the biggest one. You've got, if I remember, it's 40,000 cross-border commuters. But of course, for the border region, this is a very big issue. This is of highest importance. So there's still a lot of room to progress. There's bilaterally, multilaterally. If we look to the Nordic Convention, is there coordination at the EU level? I don't know. Again, it's to transmit the message that we are ready and willing to step in. We have to see what happens with the task force. There is readiness, willingness from our side. Thank you very much.
Thank you. And thanks to all the panelists for their conclusions and for being here. Give them a warm applause. Specifically, with all the work the task force has done during the Belgian presidency, I would also like to thank specifically Nicolas Watteau, Harald Pierrard, Ingrid Lachey, Michel Massard, all the people who have worked, the people of the service of Wendy Ruland who have worked very hard to achieve this. We tried to make the world a bit better, I would say. We tried, but this is just the beginning of the debate. Clearly, the topic will continue to be of importance for all of us. Thank you all for being here, all the people online also, and a special thanks to the person who has organized this colloquium, Annemie Helsen, give her a warm applause, of the Coordination Service of International Relations. I wish you all a very good evening, and all the panelists are invited to the stage for a last picture together.